Yes, ma'am. Good morning.
Good morning, Your Honors. My name is Rebecca Jacobstein, and I represent Daryl Kelsey. Mr. Kelsey was entitled to the disclosure of the confidential informant in order to effectuate his right to present a defense at his probation revocation hearing. The ruling in Rubiero compels this result.
Is Rubiero a case involving a probation hearing?
It is not. It is a trial case. However,
Are probation hearings the same?
no, but the most important similarity between a trial and a probation hearing, the final hearing, is that they are final hearings on the merits. It's not like a motion to suppress or a preliminary hearing, but it's the final adjudication of the merits.
Don't we say in probation hearings hearsay comes in, for example?
Yes, hearsay does come in.
Doesn't come in a trial.
That's correct, Your Honor. However, there is a difference between allowing hearsay under the Due Process Clause at a probation violation hearing than disallowing access to evidence access to the confidential informant. And the main thing is that with the hearsay, you can determine if someone's telling, you can show bias. You can, at least if you know where who the person is, you can show bias. You can contest the informant's reliability. Maybe you could even call them as a witness. When you don't know who that informant is, you can't do any of those things.
Now, during the course of the hearing, did defense counsel cross-examine the police officer and say, who did my client sell to?
She did not specifically ask that question. After losing the motion, she did not. But the court in Rubiero explains why it would have been helpful. The facts in this case, the underlying case, are very similar to those in Rubiero, and the court in Rubiero explains why the confidential informant is necessary at trial, and the Commonwealth conceded it was necessary at trial.
Actually, it's been a while since I read Rubiero, so I apologize I didn't go back to it. In Rubiero, was the CI not only a percipient witness, but the person to whom the drugs were sold?
Yes, in Rubiero, it appears that he set up the meeting, drove to the meeting, took the package, and left. And there was no, there was an officer, I think maybe in the trunk, but he was the percipient witness. He did everything. And that's what happened in this case, which is the confidential informant called on his cell phone. He drove by himself to the area with the police in a different car behind. Then a person got in the car. There was an exchange of some sort, according to the confidential informant, according to the police officer, and then he left. And the police officer was watching from behind a bush somewhere nearby.
Well, what was the defense in this case, by the way?
At the probation revocation hearing? Right. Well, her defense was that, in addition, that there was no proof of drugs, that the drugs were in fact drugs.
There was no certificate from
the laboratory,
no testing.
Yeah, right, there was none of that. It was also that there was no proof that Mr. Kelsey was the person who did it.
I thought the police officer saw Mr. Kelsey.
Well, he says he did.
Well, but he testified. The police officer testified.
Yes, the police officer
The confidential informant was searched, had nothing, was given $100, made the phone call, went to meet Mr. Kelsey. They were observed meeting together. Confidential informant came back, was under observation for virtually all this period of time, if not all of it. Was searched, had 2 twists, and the money was gone. Had 2 twists of crack cocaine, and the money was gone. It was a 40-second transaction.
It was very quick, Your Honor, yes. And
okay.
But the confidential informant is still necessary.
Why?
Well, in addition to being able to disclose any entrapment in this particular case, he could have, the officer says he saw Mr. Kelsey from some distance away.
Does your client say he was entrapped? Did he produce an affidavit saying?
No, not in this case. Not in and
did he testify at the probation hearing?
He did not. He did not. But the confidential informant could have said, no, it wasn't this guy, or he could have said, no, he didn't know what he was giving me, or no, he did not sell it to me.
Could have said all of those things. What does your client say? Does your client, in some fashion, make a case for why the confidential informant could provide this kind of information?
Well, my client asserted his right to remain silent, and my client doesn't have to show prejudice or...
Why not?
Because he was denied access to the evidence. He doesn't have to... You can't show prejudice in these types of cases when you don't know what the evidence is going to show.
Sure you can. Your client can say, just as you've suggested, I was entrapped. I told him this was really not crack cocaine. This was candy. I mean, your client can sort of say, and the confidential informant would confirm that.
Well, but my client has a right to remain silent, and this court has found courts have found in confidential informant cases that there is no requirement to show prejudice in order to get confidential.
That's in a trial context, because, of course, the burden is proof beyond a reasonable doubt, and if the confidential informant who participated in that transaction, in that context, might have material evidence on the question of reasonable doubt. But this is preponderance of the evidence.
And even before, I mean, even in a trial context or before a trial, if you're looking for the name of an informant, the defendant has got to put some evidence, often, forward, at least by affidavit or something, as to why there is reason to think that why there's a right to get this particular informant's name. Isn't that so?
Well, if the informant is a precipient witness, he's entitled to it. And so the showing that he would have to make is that he was a precipient witness, which he was able to do in this case.
All right.
And while the preponderance of the evidence is a lesser standard, it's still what's important at a probation violation hearing, and the purpose of Article 12 and the purpose of the Due Process Clause is the ascertainment of truth. And so denying him access to this denies him evidence that he could put forth so that the court...
This is all very hypothetical. It's all very hypothetical, though. It could be that maybe this person has some information. I'm not telling you why I think that. I'm not giving you any basis to think that. It just could be.
Well, he does have information. Whether it's
that would exonerate me, that would shift the balance, that would likely result in a different outcome.
No, he doesn't have. We would argue he doesn't have to put forward that duty because he does have his right to remain silent.
Now, the telephone records, I assume, were designed to potentially show that the telephone calls which were described or suggested never happened.
That's correct.
And so there was at least so counsel at least was exploring the possibility that that this thing never happened, or at least
yes, that
didn't
there was
happen the way.
actually no confidential informant. Yes, Your Honor.
Have we ever seen, this is basically a controlled by being used for a probation revocation? Is this something that is commonly done? I've never seen it before.
They originally had charges, but they had to...
well, I understand.
Yeah,
and
I did not.
And I assume they dropped those charges because they recognized they would have had an obligation under Riviera to produce them, to produce the CI. I've never heard of a probation revocation hearing based on a controlled by before. Is this something that is happening, as far as you know?
I don't do trial work, so I don't have any basis at what's going on the ground. But I haven't read any cases about it. But on that note, of course, the confidential informant is not required for a motion to suppress, and because there's it's a prophylactic rule for the motion to suppress to deter police misconduct. But here it's different because we're looking to find out exactly what happened, whereas a motion to suppress is filed to take away evidence from the trier of fact. This is to put evidence in front of the trier of fact. And since it's a hearing on the merits, he should be entitled to this information. And at least one Justice Douglas, in his partial dissent in Morrissey, recognized that confrontation with a confidential informant may be necessary for a fair hearing, and because it goes to the ascertainment of truth.
Right, but the issue here is not whether or not that your client had the right to confront. That is whether or not the government was obligated to call the CI. You're not claiming that the government had an obligation to call the CI, are you?
Absolutely not, Your Honor. We're saying that...
So the issue is simply whether or not you're entitled to know who your client's alleged to have sold to.
Right. It's a precipient witness so he can present a defense. And
But you can be a precipient witness without being the person to whom the drugs were sold. I mean, you could be present and precipient without necessarily being the buyer or the seller. But here, the claim was your client sold to a particular person.
Right, that he was really the only witness to the transaction itself.
But it just, I'm having trouble seeing where you draw, and maybe you don't. Is there any line between the fact that this isn't a trial, it's actually a probation revocation on a prior offense that you're not questioning, he was either found guilty of or pleaded, I don't remember, pleaded guilty to. But he's got a conviction, he has a probationary sentence, this is a probation hearing, but it sounds, everything you say sounds very much like these are his trial rights. And so I'm what's the difference?
Where I'm drawing the line is actually on the right itself, which is the right to present the defense. Whereas other due process rights can be limited because you have less process due, like confrontation. The confrontation of hearsay, it's got to be reliable. The right to present a defense is the core right, which all the other rights are actually protecting. You have a right to counsel so you can to help you present your defense. Counsel's ineffective if you are denied a substantial ground of defense. Written notice of the charges helps you know what you're defending against. Presentation, giving you the evidence in advance, helps you know what you're defending against. And same in cross-examination is one way in which you present a defense. The right to present a defense in these circumstances is the definitive right. And because it goes to the court's ability to determine whether the revocation is proper. And that's the purpose of due process, is to make an accurate determination of the propriety of revocation in this case. And so that's where I would draw the line, is saying you have this right to present evidence. That at the probation violation hearing, that's, I would say, akin to the trial right to present evidence, because it goes to the ascertainment of truth. It goes to whether what the government's saying is in fact the case. I just wanted to also discuss the standard of review in this case, because this was brought up in our briefs, that we're maintaining that the total denial of the access to evidence is basically exclusion of the right to present a defense, as opposed to the exclusion of evidence, which is hearsay. So we're asking this court to apply the harmless beyond a reasonable doubt. And unless the court has any further questions.
Thank you, counsel.
Thank you, Your Honor.
May it please the court. I'm Kenneth Bressler, Special Assistant District Attorney representing the Commonwealth.
Mr. Bressler, you're not contending, I take it, that the court could never order the disclosure of a confidential informant in the context of a probation revocation hearing, are you?
I'm not arguing that.
Which is sort of what the judge was saying. I would never allow such a thing. I've never allowed such a thing, never heard of such a thing.
Well, it's
possible.
It's possible under due process.
Okay.
But due process and Roviero do not compel disclosure of an informant in probation hearings, let alone trials, and the probationer was not entitled to the identity here.
Doesn't it mean, do we have now a world in which somebody is faced with a prolonged loss of liberty, and because he purportedly sold drugs to somebody, and when he asks, who am I accused of having sold the drugs to, the answer is, we won't tell you? That's what you're proposing.
What I'm proposing is along the lines of Morrissey, which recognized that a revocation of probation is not is a revocation of a contingent liberty, and
well, it's a little bit different. That's a parole. Morrissey's parole. This is probation. The judge gave a probationary sentence. The person is not looking at any time in prison unless the person violates probation, and when the person violates probation, the person can get up to the maximum sentence that was imposed. The stakes are quite substantial.
The stakes are substantial under the probation and parole cases establishing due process rights that are necessary at revocation hearings. A probationer is not entitled to the full panoply of trial rights. It's only a contingent liberty that is at stake.
But they're permitted to present a defense and to call witnesses, right?
They are permitted to present a defense.
Who's
but
the key witness in this case? The confidential informant. But how can they call a confidential informant if they don't know who he is? And the government knows. So how can they call that witness?
Following up, Justice Cordy, on your questions to the probationer's lawyer about the defense in the probation hearing, the argument to the judge was that the substance sold was not drugs. The issue was not entrapment. It was not raised in hearings. It was not raised in cross-examination. As a matter of fact, at the end of the probation hearing, when the probationer's lawyer renewed her objection to not having the identity of the informant, the judge said, "I don't understand why it's necessary." And instead of answering, instead of saying, for instance, entrapment, the probationer's lawyer said, "I just renew my objection."
Well, so the defense was that these twists weren't drugs? Is that what you're saying?
That's correct. There was no issue of entrapment. To talk about entrapment now is a post hoc justification for the motion. The probationer's lawyer could have explored that issue on cross-examination with the police officer. What were your instructions to the informant? What were any deals or incentives that the informant gave? What was the conversation that you had with the informant? None of that was explored because entrapment was not an issue.
So and was the defense based on the fact that there was no testing of the drugs?
That was the defense.
So, but going back to my earlier question, you're saying it's fine for the Commonwealth to deprive somebody of liberty at a probation revocation hearing without telling them to whom they're accused of selling the drugs? It's a yes or no.
In a probation revocation, if you're asking for a yes or no answer, the answer is yes. It is okay for the Commonwealth.
If you're right, the Commonwealth now can use controlled buys not only to obtain probable cause for a search warrant, but they can use controlled buys to revoke probation.
Presumably it could. There's no evidence that it's happening.
It happened here.
I don't believe it did so for the purpose of revoking probation.
That's the sole basis. Well, apart from the technical violations, but you don't even brief, which you don't even respond to in your brief. So I assume here it's a controlled buy is the basis for the revocation.
It becomes the basis for the revocation. The purpose of it was for crime control purposes. The probation department, there's no evidence the probation department was involved in it or instigated it. The police did so. A charge was brought based on that third set of drug offenses that was ultimately dropped because of Roviero, the benefit due to the defendant under trial rights, but not due in probation hearings. And
are you aware? I mean, I've been in this business a long time. I've never seen a controlled buy used for a probation violation. Is this something that is now being done? Is this?
I am not aware of the probation department initiating controlled buys so that probation can be revoked.
I'm not saying probation initiated. I'm saying I've never seen a probation violation based on a controlled buy. Period. Never heard of one
without
until
being
today.
able to cite a reported case. I am assuming it's happening. That cases are being dropped because an informant is involved, but the cases still proceed to probation revocation. And I argue that there's nothing wrong with that. As a matter of fact, if
I mean, how is a defendant in this particular case supposed to say it never happened if he or she doesn't know who she's alleged to have sold to?
The first way to do that would be by cross-examining the police officer on various aspects of the transaction that were not privileged, and the probationer's lawyer decided not to pursue that.
So you're saying it would have been fine for the defense lawyer to ask the witness, even in the context of the judge's order here, to say, who was that person who you say my client sold drugs to?
Well, that would have been covered by the privilege, but if
so that wouldn't be allowed, according to you.
That would not be allowed.
So the person would not know who the person is alleged to have sold to.
In some circumstances, that might be the case, but if the reason for that is to preclude entrapment, the probationer did not pursue that.
Well, how about, I mean, the person was clearly pursuing cell phone records to at least explore the possibility that the phone calls which were described never happened, and the judge didn't give the person adequate time to do that. I mean, what's a defense lawyer supposed to, how's a defense lawyer supposed to defend a case with the possibility of exploring whether this never happened without knowing who the person is alleged to have sold to?
Well, if entrapment had been the defense, and in a future case, if entrapment is a legitimate defense, it can be done through cross-examination. But the full panoply.
Okay, but you're assuming entrapment assumes that the person concedes that it happened. Here, we don't. I mean, if I'm saying you sold drugs to somebody on this date, I'm not going to tell you whom. How are you going to ascertain whether it happened or not? You don't even know. I mean, I guess you could say I never sold drugs, but how are you supposed to defend against that when you don't even know who the person is to whom you sold drugs? Where do you start?
You start the same place probation revocation hearings start, when the identity of the informant is not available and it is not a violation of the due process right to cross-examine. Now, the due process right to cross-examine informants is akin to the due process right to call them, which is at issue here. It is more akin than the due process right to put on a defense at a probation hearing, because the due process right to put on a defense does not run into a long-established and legitimate government privilege of not revealing identity of an informant. The due process right to cross-examine an informant runs into that privilege and is therefore more akin and is therefore instructive. It is not a due process violation to preserve the safety and the life of an informant.
But you would agree, the very reason why you dismissed the criminal cases here is that where the confidential informant is a recipient witness to the crime charged, then the disclosure is virtually mandatory in the trial context.
Virtually mandatory in a trial context.
Why not here? Same issues?
Because Roviaro said that no fixed rule with respect to disclosure is justifiable. And we know from probation revocation hearings that they're not part of criminal prosecution, and the full panoply of rights in a trial is not due in probation revocation hearings.
Well, if you're right, and I take it that all of these due process rights really are fact specific. They really depend on the case. And in this case, I take it there was no evidence, or at least no expert evidence, that whatever was found was a Class B controlled substance. There was no expert testimony.
That, I believe, is the case.
So doesn't it become more important here for the defendant to be able to cross-examine the confidential informant as to what he bought or what he thought he bought?
Not necessarily, Your Honor. And as a matter of fact, the case provides more problems than have been discussed so far, and that's what I want to raise. Probation hearings are the province of the aegis of the judicial branch. In a trial, the executive branch makes decisions on priorities. Do we want to proceed with this criminal prosecution and sacrifice the utility of this informant in future cases? They're weighing priorities and makes that decision. Probation hearings involve the judicial branch, thus becoming dependent on the executive branch to agree to allow revealing the identity of an informant. The judicial branch would be hindered in carrying out its own duties, and it's possible that trial judges would be less likely to impose probation and instead just send drug defendants to jail, reducing them further of the benefit of probation.
So I take it what you're saying is that, maybe I missed this argument, is that the judge really could not have ordered the Commonwealth to disclose this information, or the Commonwealth had already decided to dismiss the cases.
It would have been,
but could have said, well, I don't think this. this probation revocation hearing can't go forward consistent with due process.
The judge could have done that, but the exact procedure by which the judge would have orders the executive branch to reveal the identity of the informant is problematic.
Well, I mean, but that's what the judge could have done. Just could have said to the probation department, you can't go forward.
The judge could have done that under due process, but due process certainly did not require it. And the probationer in this particular case was certainly not entitled to that information, because only the day before the probation revocation hearing did the probationer's lawyer file this motion seeking identity of the informant. It wasn't heard until the day of the probation revocation hearing. The Commonwealth was not present. Even had the Commonwealth been present, even had the Commonwealth opposed the motion and had the judge granted the motion over the Commonwealth's opposition, the probationer was not going to be able to get the informant then and there. He was scheduled for that day.
But that happens in state federal law enforcement issues where the feds are in possession of certain evidence, and a judge may say to the prosecutor, I want you to get that evidence from the feds. The prosecutor may not be able to get that evidence from the feds, so we continue the case and makes the request, and if we don't get it, that could be the end of the state prosecution.
But the judge was within his discretion in saying, you know what, this probation hearing is going to go forward. We do have a police officer here, and this is akin to the probationer's lawyer twice telling the court, on the day of a scheduled hearing, phone records aren't here. Instead of bringing this problem to the attention of the court before, logistically, the identity of the informant was not going to be available to the probationer on that day, and the probationer's lawyer did not look ahead to it, may have simply been seeking a dismissal.
You're making 2 points. One, I thought you began by saying you're never entitled to this stuff, and now you're saying, well, in this case you're not because it was too late. So is it both, or one, or what?
There's no blanket rule entitling a defendant or a probationer to the identity of the informant. There are conceivable circumstances which due process would entitle a probationer. In this particular case, the probationer legally was not entitled, and factually and procedurally was not entitled because of for reasons of delay.
Counsel, your time is up.
Thank you.
Thank you very much. We'll take a brief recess.